Hi, everyone. This is Sam Silverman, Managing Partner of EB5 Affiliate Network. Thank you for taking time to join us today. On today's webinar, we're going to be talking about various strategies to expedite or accelerate the EB5 approval process. As many of you know, USCIS, United States Citizenship and Immigration Service, unfortunately has been plagued with longer than expected processing times at various stages of the EB5 immigration process, and that has caused significant delays for investors seeking to complete the immigration process and obtain their permanent residency through the EB5 program. And so today we're going to spend some time and talk about the different stages of the process and discuss with our distinguished guests, Rohit and Stephen, about what some of the options are for investors to try to accelerate that process. So today's webinar will be recorded, so there will be a video link that can be accessed and will also be available on our YouTube channel. If you're interested in getting a hard copy of the slides, please email info@eb5an.com and we'll be happy to email you a PDF file of the slides. During the webinar, if you have any questions, please use the chat box on your screen to send those questions into us, and we'll try and cover as many of those as we can at the end of the webinar. So again, if you have questions, we're not going to be stopping during the webinar, but we will try to cover as many of those questions at the end of the webinar during our question and answer session. So first, a quick overview of what we're going to be covering today. First, a little bit about EB5 Affiliate Network, or EB5AN for short, and about Saul Ewing, Arnstein & Lair, the law firm where both of our guests are practicing at currently. We'll chat about the EB5 process and USCIS adjudications historically and at present. We'll talk about administrative remedies available to investors as well as mandamus actions. We'll spend a few minutes chatting about 2 EB5 projects that we currently have available for investment. And then at the end, we'll open it up for questions and answers that have been sent in to us using the chat box. So first, before we jump into the content, for those looking to set up their own EB5 project, most EB5 investments are in targeted employment areas or areas with $900,000 as the investment threshold. Our TEA map, newly launched with the most current data, allows you to immediately determine if a project site qualifies as a TEA. So it's completely free, available on our website, eb5an.com. You can type in the address and immediately see if your project qualifies, and also generate a free TEA report as well. For those looking for a little more detailed information about the program from an investor's perspective or from a developer's perspective, we recommend as a first step to review our EB5 guidebook. It's in its 6th edition. It's also available completely free at eb5guidebook.com or on amazon.com for a hard copy as well. Now we'll shift gears and chat a little bit about EB5AN and Saul Ewing, Arnstein & Lair. So EB5 Affiliate Network, we're a national EB5 regional center operator and fund manager. I'm Sam Silverman on the left side of the screen. My partners and I got into the EB5 space about 7 years ago and tried to bring a more institutional approach to structuring and managing EB5 investments. This is a little bit more information about the company. We have almost 2,000 investors from more than 60 countries, with many regional centers covering most of the United States. This is a quick map showing some of our regional center coverage around the country, and another global map showing where some of our investors come from around the world. And most importantly here, investors from a wide variety of backgrounds have consistently found value in our investment approach to the EB5 program. And now we'll switch over and I'll quickly introduce our guest panelists, Rohit Kapuria, a partner at Saul Ewing, and Stephen Reingold, also a partner at Saul Ewing, We've worked together with them extensively over the last several years, and it's my pleasure to have both of them join us. And I'll let Rohit first jump in and introduce himself, and Stephen as well.
Thanks, Sam. This is Rohit Kapuri. I'm one of the attorneys out of the Chicago office for our firm. We are a nationally recognized firm, about 400 plus lawyers, I believe 17 offices around the country. And with respect to EB5, we kind of run the gamut of representing large threshold of investors for various functions on 526s, IA-29s, for Mandamus petitions, which we'll be discussing today. But we also represent regional centers, borrowers, EB5 lenders, and banks. We kind of run and cover the gamut and gives us a good visual of the entire process. Very happy to be here.
Hello, everyone. This is Stephen Reingold. I'm also happy to be here. Thank you for having me. I work out of our Boston and New York offices. My focus is in complex business litigation, which includes the type of mandamus actions that we'll be discussing today. I've worked with Rohit on a lot of these matters and look forward to discussing them with you.
Great. Thank you, guys. Rohit, do you want to share a few words about Saul Ewing generally, and particularly their experience in the EB5 space over the last 10 years?
Sure. So we've done, at this point, probably $8.5 to $9 billion worth of EB5, and that's again running the gamut and functionality of representing various different groups from a transactional standpoint. And specifically on the investor side, we have a very good base for investors from India, as well as from Latin America, which is a wide variety, obviously, and then to a certain lesser degree from China. The nexus of where we've done as well is on various redeployment cases. So a lot of investors that go into projects that end up redeploying, we structure those deals as well as advise on the immigration component and also on the loan transactional framework. So it gives us a very good purview for investors. And then as we work with the investors over a time period, we're able to assist them on the tax planning, pre-immigration tax planning, going forward, private equity investments, to the extent the investors end up setting up their own intellectual property sites, or they need assistance on healthcare law, anything of that nature. We have sort of that wraparound legal platform to assist.
Great. Thank you, Rohit. Okay, so before we jump into the specific remedies and mandamus actions available to accelerate the EB5 process, we're going to spend just a few minutes talking generally about the different steps of the process and where some of these actions can be helpful for investors just starting the process, or those who have already been in the process and are delayed in one of the later steps. So high level, a mandamus action can help investors overcome delays when awaiting approvals during the immigration process. So there are basically 5 major steps in the process. Initially, submitting the I-526 petition, waiting for approval. Then second step, waiting for the visa category to become available or current, essentially. This is primarily an issue for investors from China, Vietnam currently, and potentially India in the future. Third, after that has been accomplished, after there is a visa currently available for you to get, then you'll be adjusting your status either in the United States or out of the United States. The form is slightly different. And then once that adjustment is completed, then you actually start the 24-month conditional residency period. Then once that's completed, then the final step is the 829 removal of conditions, which makes that temporary green card permanent. And so today, what we're going to be focusing on is the mandamus action and other administrative remedies for how investors can expedite or accelerate through delays, primarily applying to steps 2 and 3. on this particular slide. And so I'll let Rohit and Stephen jump in here and kind of take us through the content of, what has been causing these delays recently and what their proposed remedies are for helping investors who are, facing an unfair delay.
Sure, I'll take the first stab of this, and then I'll defer to Stephen on sort of the remedy component. But there are various different factors for delays over the years. Some historical context here. Initially, when EB5 began to increase in volume and petitions over the last decade or so, there was a shift of the EB5 center, if you will, processing adjudication center, from the California Service Center down to the Washington, D.C. office, which basically became the investor program office. And part of the argument at that point in time was they wanted to silo the EB5 functionality into one office. They wanted to, they being USCIS, wanted to retain high-level GS15 and GS16 level employees, which from a government perspective are those which are, they have a track record and they have a resume that's a bit higher than the average USCIS officer. And they wanted to, break apart some of the legacy framework of delays over the last few years. They really wanted to give it a boost, if you will. Now, from an issuer perspective, as they did that, the initial feedback from USCIS at delays at that point was, look, we just moved offices, we're still trying to set up, we're still trying to staff up, and therefore bear with us. During that time frame, there was also an substantial increase in the number of petitions, particularly driven from China and Vietnam at that point in time. And so the agency, or the IPO, was drowning and wasn't able to keep abreast. Part of the increase was also due to the fact that we were pending legislation, which the rumors about legislation and the bills that circulated started in 2015, but didn't actually take place until 2019. And so that began as a first excuse. Subsequent to that, when they did staff up, then the sort of feedback we got was, look, we're now fully staffed, but we're trying to play catch up. Then the next feedback was, okay, we're trying to catch up, but we're also trying to push through this new regulation that was supposed to take effect in 2019. Then the next feedback was, well, we have pushed through regulation, but we're trying to staff up and train our officers. And then the next delay after that was, well, COVID, right? And so for investors, the frustration on the I-526 and the subsequent applications was, continued. And in 2020, during the midst of the pandemic, USCIS actually also changed the processing, where they moved from a first in, first out process, which means that if you filed on February 19th and somebody else filed on February 20th, technically the guy who filed on February 19th would be ahead of the queue. But USCIS said, well, that doesn't make sense because there's a visa backlog for countries of China and Vietnam in terms of those investors born there. And so we will have to look at this first in, first out process on the basis of whether or not there is a visa available. So as all of this was rumbling and all these delays were in the midst, a lot of investors obviously were frustrated. A lot of regional centers were frustrated. A lot of funds were frustrated. And so as a firm and along with the industry, we started to file a number of these mandamus cases, specifically with respect to the I-526 petition delay. So Stephen, kind of coming in on that framework, maybe you can describe a little bit of that process from a delay and what you outlined in the complaints for USCIS.
Sure, happy to. So what we have done and what others in the industry are doing is we will file complaints on behalf of petitioners whose petitions have been pending longer than the estimated average or range published by USCIS. And the way it typically works is we file a complaint in the nature of mandamus in a United States district court, either in the district in which the project is pending or in Washington, D.C. And what a mandamus is, very briefly, is a request that a court order an administrative agency to take an action it is required to take. Our argument, in essence, is that USCIS and the IPO has unreasonably delayed in processing the 526 and the other petitions, and the excuses that it has given, amongst those are the ones Rohit just explained, and there are some others, that notwithstanding those excuses, there is a regulatory and statutory obligation to act expeditiously. The other excuses we're seeing is, in addition to the pandemic being the latest excuse, that there was a lack of funding. That never came to pass because the funding was there. There were layoffs threatened. Those layoffs did not occur. It's basically one excuse after another. So what we have done is file these mandamus complaints to get the attention of the agency, of USCIS. And in a nutshell, the way it works is once we file the complaint and serve it, the agency and the other defendants whom and which we sue have 60 days under the applicable rules to file an answer to the complaint or a motion to dismiss it. But long before that, an assistant U.S. attorney, which is an attorney for the federal government, will appear in the case and we will start a dialogue. And that dialogue often goes along the following lines. We have a petitioner who is very frustrated. Your agency's delays are unreasonable and something needs to be done. I would like you to go to your agency and find out where we are in the queue. And the quid pro quo for that is we will agree to extend that 60-day answer deadline while the agency works through the process. More often than not, if not after that first extension, another shorter extension, lo and behold, the 526 is in the queue at the top of the pile with an adjudicator. And so we're able to get the attention of the agency and get things moving simply by starting this kind of litigation. And then once there is an adjudication, the lawsuit can be dismissed. And this is the approach we've been taking for the 526s and are looking at actively and now beginning to file for adjustment of status applications as well.
Got it. Thank you, Stephen. With that in mind, let's shift over now to the next slide and talk about the current range. As of earlier this morning, the currently posted range on the USCIS site is 29 to 57.5 months. So can you kind of explain, what happens for an investor who, maybe they've been waiting 4 years, 48 months? Does that person, have no hope and they have to wait until 57.5 in order to even try this? Or is it just a likelihood of success, incremental step change difference if they're outside of the range? And what about somebody before, less than 29? How does that impact? And then lastly, what about, existential circumstances, there's a health problem or, other kind of issue like that is kind of out of the ordinary, not just they don't want to wait longer.
Right. Well, I will start, and then Rohit will tail in behind me. The answer to your first question is somebody who is not at the higher end of the range is not precluded from taking this action. We have filed these actions successfully on petitioners who are at the lower end of the range, or indeed not even yet within the range, but will be shortly. And the reason for that is twofold. One is that the range changes almost daily. And two is, just because this is where the numbers are now, does not mean that the delays are appropriate. The delays have been creeping up over the years, and when most of the petitioners whom we represent initially filed their 526s, the estimated range or the average processing time was much, much shorter. If you look at the historical data, you go back into fiscal year 17, fiscal year 18, it was far fewer than 24 months for an average processing time. So here we are now, we are looking at least 2.5 years and far beyond that. So we don't view the range as dispositive and say, no, I'm sorry, you're not yet at 57.5 months, so we won't do that. We see that as a non-issue and continue to file these cases.
Yeah, I mean, the one thing about the range that's interesting is the numbers, as Stephen mentioned, they've been creeping up, but there was a drastic increase in the presentation about 6 or 8 months back. Ironically, it also coincided with the fact that a lot of petitioners and their counsel were also filing mandamus petitions. And so one sort of starts to begin to question, well, is that really accurate or is this just arbitrary? The other component is you have to remember, we have USCIS and the IPO, it's one siloed office. And so the delays that are plaguing the agency do not necessarily mean they're plaguing the IPO. Yes, there is a restriction from a perspective of working from home. The fact that USCIS requires that we provide very large swaths of paper because these are all paper filings, they're not electronic. The fact that USCIS requires that for every petition that's filed, we also have to include the project documents. And so theoretically speaking, if an adjudicator is working from home and they come to the office and pick up a number of adjudications, well, by the time you get 5 banker boxes, you've only picked up 5 petitions, and maybe your car doesn't, can't allow you to take more than that. So there are restrictions there, and we do understand, but it doesn't mean that this number is something that we should adhere to, because it is not reasonable. EB-5 petitioners are making a very large investment, and EB-5 petitioners are also paying at the higher level from, with regard to filing fees as compared with the rest of the other immigration programs. So it is a fee-based agency, and they have the resources and they have the capital in order to service this. Now, as far as, Sam, what you were mentioning, if there are other health reasons or anything unique to the investor, that's not really a mandamus petition. There are ways to file for an expedite. The problem is USCIS's view on what an expedite is highly discretionary. Really, typically tends to be with respect to an individual who has, unique health issues or is contributing to national security, or there is some other purpose that fits within these 4 or 5 categories that the agency has presented. And we've successfully received expedites on clients, specifically during 2020, those that were involved in COVID research or some sort of medical research that triggered it. But we've also seen situations where we've had petitions denied, even though they were health related. I had a very serious case last year where the petitioner had a major health problem. Would definitely be deemed to qualify for an expedite, and USCIS denied it. And of course, we pushed back hard and went through 3 rounds before the agency finally approved it. But it's for when you get into those type of circumstances, those are outside of the legal framework. They're not litigation related, and they're simply application for relief under normal USCIS processes.
And just one additional point I'd like to add about the delays and what we have learned through bringing these mandamus actions is, notwithstanding the fact that the adjudicators are working remotely and have to pick up the files every now and then, we have discovered through our conversations with some of the assistant U.S. attorneys that in any given month, an adjudicator is taking 200 to 300 526s home to review. So while there is a very large backlog, you multiply those numbers by the numbers of adjudicators, and there really is not what we believe to be a good justification for this kind of delay that we're seeing.
Got it. Okay, that makes sense. Rohit, could you talk a little bit about Charles Oppenheim and kind of what his role is and what some of the recent statements that he's shared about the processing timeline and visa availability?
Sure. I'll start off by saying Charlie is a really cool dude. From a job security perspective, he's the one guy within the State Department who understands just how visa allocations work. He's sort of the oracle in a way that he predicts how visas are going to be allocated on a per country basis. And he's the guy who ends up opening the floodgates, in terms of, or rather not floodgates, but opening the tap, I should mention, not floodgates, which allows for visa allocation over the various different petitioning individuals based on their country of origin, country of birth rather. And so what he's provided over the last few months, and most recently he did a presentation with IIUSA, which is the Invest in the USA, is he talked about how the numbers have been skewed. Very interestingly, he mentioned on the Chinese investor front, there were over 9,000 Chinese investors that were ready to proceed to the next step, which is a frighteningly large number. And he also gave sort of purview on just how many investors were pending. But remember, there is a cap, annual cap that applies each year. The one thing he also did tell us was how the visas have been restricted over the last year, particularly because of COVID. So embassies and consulates are closed. They're not offering immigrant petitions. There was also a freeze under the last administration with respect to immigrant petitioners. And so as a result of that, most of the petitions that we've seen that have moved have been under the adjustment of status process. So if you are within the United States and you have an approved 526 and your counsel has filed for an I-45 along with a 765 and a 131, which we'll talk about in a little bit, you are more likely to proceed to the next step versus if you are outside of the US and you're waiting for a consulate interview. We've had several clients, and when I say several, I mean a lot, that have been pending outside of the United States. And unfortunately, their country, their consulate or their embassy is closed to immigrant petitioners due to COVID or some other restrictions. So for example, Mumbai had started to open up petitions, but then the city of Mumbai has been plagued with huge influx of COVID cases over the last few weeks. And so again, we've seen a slowdown. So there are all of these restrictions that you start to look into. And what Charlie was saying and seems to be projecting is we're going to again have an excess number of visas moving into the next fiscal year as we did from fiscal year 2021, meaning so 21-22.
Got it. Got it. All right. So now we're going to shift gears a little bit and talk about administrative remedies. So I'll turn it back over to both of you to kind of comment on how the process looks like if you're going that direction instead of straight to a mandamus action.
Great. And let's importantly, we're going to be talking about three different things. There'll be a slide that comes up, but mandamus relief with respect to I-526 petitions, mandamus relief with respect to those on the adjustment of status, and what considerations, if any, for those that are sitting at the consulate level, and if there is anything that we can even do at that point. So we'll sort of mention that, though. I will say that our options are very low on the last part, which is the consulate site. So Stephen, maybe take this on the building the record framework and what you need when you're filing the complaint.
Right. So it's really quite simple as far as we see it. The complaint is really only supported by the historical filings. So the facts of the I-526 filing, facts related to the investment and the underlying project, and then we often do one or both of the following. We will inquire of USCIS as to the status of the 526 before we file the lawsuit. The reason we do that is we often get a standard boilerplate response, which is simply along the lines of, thank you for your inquiry. We have a process in place and your petition will be adjudicated under that process. More often than not, we get no response whatsoever. The other thing we do is we often reach out to the Office of the Ombudsman to see if there's any last administrative remedy, administrative path we can pursue. We don't always do that because that seems to be more often than not a waste of time. So we tend to go right to the litigation alternative after making one or two inquiries. It really is that direct.
Got it. Got it. Okay. All right. So let's shift over to talk about mandamus actions.
So, on this front, again, when we get into the path, for the listeners on the call, to the extent you are investors and or you're representing investors, the first thing that we should understand is what relief it is that you're seeking. So if you filed an I-526 petition and you believe that you have been pending for far longer than necessary, then we have to determine whether or not this is applicable to you. Now, I will say off the back, looking at the processing time on the slide before, which was the 29 to the 57-month time frame, you don't necessarily need to be at the 29-month frame, as Stephen mentioned. But also, you shouldn't be at just month 12 and then believe that this would be the right petition. We also have to make a reasonable argument, not just on the basis of what is out there, but also on the basis of what historical data shows. So from that framework, a reasonable cutoff in many instances, and various litigators and various attorneys will differ, but at least from our standpoint as counsel and what we've done, is we believe that somewhere around the 22 to 24-month framework would be a better case than if you were less than that. Does it mean that you cannot file it at month 20? No, you can. It's just a question of whether or not you would be able to succeed. And there are cases. There are a lot of attorneys out there who have succeeded at 20 months, at 18 months, at 19 months. It's just from our standpoint, as a rule of thumb, we think somewhere around month 22 or 23 is a much stronger case. So we'll talk about, Stephen will kind of explain what that process is on that element. And then once he finishes talking about the administrative process of filing the mandamus, we will then shift gears onto seeking relief for those who are at the adjustment of status level. And then subsequent to that, we'll talk about what the consular level looks like. Stephen.
Right. Thank you. So as I said before, the process for the mandamus action is really quite simple, and because we do a lot of them, we can do it in a fairly streamlined fashion. So we draft a complaint that lays out the history of the filing, the delays associated with the processing of 526s, the particular petitioner's facts and circumstances, the project's particular facts and circumstances, if there's been an RFE or not for the project on a 924. And then we argue that under the applicable regulations that the process is taking far too long, and we ask the court for relief. As I mentioned before, we often get the attention of an attorney from the government fairly quickly, and we start negotiating rather than full-blown bare-knuckle litigation, because these kinds of cases don't require that. They can often be resolved with, a few conversations and a little bit of patience on our part to allow the process to work, but we are not finding it to be the case where we're dragging into years-long litigation about the merits of the petitions. We don't ever get there. In fact, I cannot think of a recent one we have filed where the government has actually had to file an answer to our complaint, because with a couple of extensions and a little bit of patience, the petitions have risen to the top of the queue and they've been adjudicated. Or an RFE is issued, a request for evidence is issued, we respond, and then the petition is adjudicated. So the process really is aimed at getting the government's attention. The government will tell us, we are not going to take your petition out of the queue, but funnily enough, we get attention and we get adjudication. So it's working. And that's what we've been doing with the 526s.
Now, a common question that I typically get from investors is, will there be an adverse result on the adjudication because you filed a mandamus? So the fear is it's litigation, right? And certainly there's a human element to the litigation, and there's a human element to the adjudicator's response. Is it possible that they get annoyed that that this particular investor that they're about to adjudicate, or which all of a sudden just landed on your desk, filed a mandamus against them? Sure, that's possible. But it doesn't mean that that particular adjudicator will have carte blanche to all of a sudden issue you an unreasonable notice of intent to deny or unreasonable request for evidence. So what we typically do is, if we are taking on the case, and assuming we didn't file the I-526 petition, we would want to review the source of funds and the I-526 petition that was filed, just to see if there were any loose ends. So there've been a few circumstances where we've reviewed it and we've actually turned the client away and said, listen, we don't think you have a very strong I-526 case. And so if you file a mandamus, you may be inviting a more severe response or adjudication from USCIS. Again, it doesn't mean that that's necessarily going to be the case, but in those circumstances, I don't want to give the adjudicator additional armor to come after the investor in a more difficult manner. Now, that being said, if you were bound to get an RFE, you would get an RFE regardless of whether you filed a mandamus or not, right? That's always going to be the case. If there's something lacking, or there's something inconsistent, or there's something deficient and or missing in your petition, you will get that response. But it doesn't mean that you should be scared to proceed with the process just because you're concerned that USCIS is going to have a more adverse relationship. Of course, always speak with your attorney before you make a decision to proceed with mandamuses.
Got it. Thank you, Rohit. Okay, so we talked about that. Maybe spend just 1 or 2 minutes kind of quickly wrapping up, for those investors who are looking to actually go forward, what does that process look like? Timeline, cost, how does that, in terms of timeline, getting up to speed, filing the action, and then, hearing a response? I know we touched upon it earlier, but just what's the whole thing look like?
Sure.
Sure. And then Sam, right on top of.
Go ahead, Rohit. Okay, well, I'll jump in. So the process begins with the review, as Rohit said, of the petition and supporting documentation that we would want to make sure we have a solid basis for filing this claim. That doesn't take terribly long. It really depends on how soon we get the information. Drafting the complaint is fairly straightforward. It does not take very long, simply because we've done a lot of these. Filing them, everything in federal court in the US is filed electronically, so it's very simple to file. And then service, when you are suing the federal government or an officer of an agency in his or her official capacity, service is effectuated by certified mail. So really the service is dependent on the mail service, which again, we're seeing usually receipt within a week or so from mailing. You also have to send copies to the Attorney General's office and to the U.S. Attorney in the district in which you have filed the lawsuit. What we've been doing, because we've been doing a lot of these, is reaching out to the U.S. attorneys in the districts in which we've been filing and saying, look, we have another one. Your clients are going to get served by mail. You're going to get a copy by mail, but here's a courtesy copy. Can we start a dialogue? And so we've developed relationships with some of these assistant U.S. attorneys in these various districts, and it gets their attention. They file an appearance in the lawsuit long before they ever need to file an answer. And again, under the rules, the initial period the government has to answer a complaint is 60 days. We'll agree to extend that for a period of time. to allow the petition to be not pulled out of the queue, but identified, and give USCIS a chance to talk. And sometimes we'll do a second extension, but we're seeing these results to the extent we are being successful. Some are still pending, longer than others. But we're seeing, certainly less than a year. In some cases, it's been less than 6 months from when we file a complaint. Each case is different, and people should understand that. Each case is different. But we're talking, an order of magnitude of months, not years. And again, we haven't had one in recent vintage where we've had to go full bore litigation with the government. Is the government doing that in other cases? Yes, it is. There have been mandamus cases, both in the 526 arena and others, where the government has filed a motion to dismiss a complaint, arguing various things, including that the period in which a petition has been pending is not out of the norm and is not unreasonable. By and large, those efforts have been unsuccessful, and the courts are allowing the cases to continue. So we're seeing a positive trend in that direction.
And then one element, in just terms of bifurcating here, I know we're pressed on time, but I want to just move us quickly into the adjustment of status. So Stephen, perhaps, on that level, because we've done a significant amount of research on this element, and as we are proceeding and we're preparing and in the process of preparing these complaints, there are different components there. So if you are here in the U.S., you file an adjustment of status. Typically, your attorney has filed for an I-485, which is the adjustment, the I-765, which is your work authorization, and then the I-131, which is your essentially a travel card. And it comes in, the 765 and the 131 come in on a combo card perspective. So a lot of investors who are here on OPT or about to get onto OPT, or they're just about to, they're graduating, or they're wrapping up their OPT or something of that nature, or there are some other visa category, and they want that flexibility to move and begin working. The 131 and the 765 are the most important elements to them. I mean, the physical production of the green card under the 485 could be longer. So Stephen, perhaps on that point, maybe say a few things.
Sure. So Rohit is correct that we are starting to get more involved in these as well. And based on our research, it does appear that those who have filed 765 and 131 are in a slightly better position to seek mandamus relief. I mean, there are some cases dealing with the 485s. Those seem to be, to the extent they've been litigated, are not going as well, but I think there still aren't enough of them to draw any conclusion. We are continuing to explore all options for mandamus for all three, but the focus of the cases that seem to be more successful so far has been the 765 and the 131. I wouldn't argue that 485s are foreclosed, and the time range, depending on the field office or the service center, they are across the board, depending where things are filed. That is a defense that the government is raising. So too with the 765 and the 131. The government is arguing in some of these cases that the delays are not unreasonable if you look at the particular service center or the National Benefit Center where an application has been filed, and not at the industry as a whole. And the reason that's important is the numbers coming out of California, certainly with respect to the 131s, skew the results. And the estimated range for 131s coming out of the California Service Center is 23.5 months to 30.5 months. When you're talking about travel documentation, that is a ridiculous delay. So too on the employment authorization, California, you're looking at 11 to 19 months if it's based on a pending 485 adjustment. So those again are unreasonable, but if somebody has filed their 131 in Vermont, for example, the range is much shorter, it's 6 to 8 months. And so it might be a harder argument to make. So these are very fact-specific cases. We would have to know more about any particular individual's situation to say whether the 131, the 765 is ripe for mandamus as well.
Got it. Got it. Very, very helpful. All right, so we're going to switch gears now and chat just for a few minutes about two currently available EB5 investment projects at the $900,000 level, and then we'll shift and open it up for some questions that we've received. So both EB5 projects that we're going to chat about today, they're both being developed by a company called the Coulter Group. Coulter is one of the largest developers in the southeastern United States. The company has more than 500 employees and operates across 4 major business divisions: Coulter Urban, focusing on high-rise condominium developments; Coulter Hospitality, focusing on hotel development and investment; and Coulter Homes, master plan community development and home building; and Coulter Land, lot development and lot banking for third-party builders. Coulter is a financially strong developer with a very experienced and strategic and award-winning management team. We've partnered with them on more than 10 EB5 projects over the last 7 years, and we've looked at hundreds of developers and continue to work with them for a number of key reasons. First, they have a very strong reputation and a very strong financial position. They've never defaulted on a bank loan since their founding. They work with many of the leading equity family offices around the country. They're one of the top 25 largest privately held home builders in the United States. They've been recognized by major hotel brands, including Hyatt, for their development acumen and execution. They're strategically focused on the southeastern part of the United States, where there's a large shift in population and demand, particularly in the last several years. And their team has worked together extensively for the last more than 30 years now, with more than $15 billion in real estate development experience. The first project we're going to chat a little bit about quickly here, and this is very high level information. If you are interested in either of these two projects, please reach out to us and we can confirm that you're an accredited investor and eligible to get additional information about the deals. So high level, the Saltaire St. Petersburg project. It's the second phase of EB5 in this project. The first phase was completely sold out already. This project is a condominium tower on the water in St. Petersburg, Florida. It's well under construction. Senior loan already in place with Wells Fargo Bank. The deal creates over 3 times the number of jobs required. Only 10 jobs are required. This creates more than 30. Construction's well underway. EB5 is about 22% of the total development cost of the project. It's a $900,000 project, and investors are receiving a 2% annual return paid each year. Coulter previously did another project on the same street in downtown St. Petersburg called One St. Petersburg. That was 100% sold out in October of 2018, well before the building was even done. And Saltaire St. Petersburg is kind of the second project, given the very strong success Coulter experienced with the previous One St. Petersburg project just 3 blocks away in the exact same downtown area. The project's also unique because it's located right across the street from Publix and CVS, 2 of the largest pharmacies and supermarkets nationally and in the state of Florida. So walking distance and just very, very centrally located with an unobstructed view of the Gulf of Mexico. The second project we have available that we've just put together is called Twin Lakes, Georgia. It's a single family home development with many amenities outside of Atlanta, Georgia. It's a rural TEA and qualifies at the $900,000 investment level. It's an equity investment project with a 5% investor return, which is very, very compelling, given that most projects are less than 1%. This project only has capacity for 6 investors, and we've already closed 2 of the slots, so we only have a few slots left. This project creates more than, I'm sorry, that's not on here, but it creates substantially more jobs than the 10 jobs that are required. All the jobs needed for all 6 investors have already been created. There's 1,300 single-family homes in total, and as of November, just a few months ago, already 109 have already been sold. And I think as of today, that number is almost at 200. Sales have been going extremely well over the last couple of months. This is a quick overview of some of the models for this development. And one of the model homes here is called Rosewood. And we'll see a quick photo of that model here. And again, if there are any questions about either of these two currently available EB5 projects, please reach out to us and we're happy to provide more information. All right, so now we're going to shift over to question and answer session and try to cover a few questions here before we conclude and thank our guest panelists. So let me look at the questions here. So one question that we got about the Mandamus process. Can you talk a little bit about the cost? How does the cost work? Is it a fixed amount of money to initially file the complaint and then it's kind of hourly or variable after that, or is it all hourly? And if it is hourly, what's kind of a general ballpark for what the cost can be for that? And is there any potential for getting some of that cost reimbursed from the government if they've really been, if there's been a really significant delay outside of the window, or no fees like that recoverable?
Well, this is Stephen. Let me work backward. In the U.S., unless there is a statute that so provides, attorney's fees are not recoverable in litigation. And this is the kind of situation where attorney's fees are not recoverable, and you also have the additional issue of it being the federal government that you are suing. So no, there is no opportunity to recover attorney's fees, unfortunately. The way we have been structuring these cases is a bit of a hybrid. We begin the relationship on a fixed fee basis. And what I mean by that is, for a fixed fee, we will do the initial review, prepare the complaint, file it, and start the process of negotiating with the United States attorney in the district in which the case is filed. At some point in time, if it comes to pass that the government does want to engage in litigation, whether by filing an answer or by moving to dismiss the complaint, then our relationship would require an adjustment where we would go to an hourly billing basis. And that, again, is dependent on the particular circumstances of each case.
Got it. And does that, what is that fixed initial amount? And does that vary by geography or not?
It varies by geography. It varies by project. It is typically within a range. So it's something we would work out with the particular client.
Okay, but are we talking like 3,000 to 5,000 or like 15 to 30?
We're talking certainly not 3,000 to 5,000. I wish it were, but we're also not talking 15 to 30. Typically, recent cases we've been doing, it's been a flat fee somewhere in the order of magnitude of 12,500 to 15,000. It really does, though, depend on the individual circumstances, but that is a general idea. And again, it covers the first phase of the action.
And then the other thing that we always consider on that is, it depends on what jurisdiction. So, being a large firm, we cover several jurisdictions where we're filing the cases, but then to the extent we're filing in a domicile where we don't have an office and or we don't have a litigation attorney who's barred within that particular jurisdiction. And these obviously, remember, even if it's one state, doesn't mean that they covered that particular circuit court or that particular, not circuit court, that particular district court, then we may have to co-counsel with a third-party attorney. We've fortunately not had to do that very often, but in those type of cases, then obviously the cost starts to increase a little bit, and so we try to avoid those as much as possible by just defaulting into DC, which is where we have an office in DC and we have a little bit more flexibility to that extent.
Okay, so two other questions we got. Have you done mandamus cases on 829 petitions?
We have not done on 829s, to the extent we haven't seen that much demand on the 829s yet. I think by and large, the issues that we've seen most times with folks, at least of recent, is if they file the 829, if they're not getting the receipt notice in time, then obviously that's a bigger issue for them because they don't have that extension. And that's been more prominent within the COVID era. Also, given that the policy also allows for investors to be able to get redeemed out of their investment to the extent there's capital available and to the extent the deal documents allow for that, most investors in our experience have not been as interested. But that's something we can explore, and certainly the data are out there to look at it. But again, the market demand has not been very high.
Got it. Okay. Is there any advantage in terms of cost savings or in, kind of results of, multiple investors in a single project facing a similarly long delay to, file together, or it's not really common and you generally, you're all filing separately and there's no real advantage at all, cost or otherwise, to, do it as a group?
Let me take that first part, and I'll let Stephen, because there's some tricky legal minefields on this. So to the extent we can do it, and I'm not saying we don't, and we've done it and we are currently in the process of doing it, there are cost savings. And we've also done these from a perspective of doing it on behalf of the new commercial enterprise. So it depends on who our client is, right? So sometimes our client is the new commercial enterprise will come to us and say, listen, we have 50 investors that are stuck here, and we would like to retain you as a law firm to represent, X number of investors who opt into the process. And then Stephen's going to talk about how that process works. And, that's one way of doing it. Another way is where investors group together and they get attached to it, but then that's, again, where the tricky component comes. And we are aware that there are attorneys out there which, will essentially reach out and grab a number of people, and then it ends up being cheaper and a whole bunch of people join. But that's where it gets really tricky. So Stephen, I know you've spent a lot of time thinking about this from the ethical component, as well as, we've discussed this in-house with our ethics counsel. So there are some components to consider as to what that looks like.
Right. Thank you, Rohit. So the issue for us as lawyers, without turning this into a seminar on the rules of professional conduct, is that when we represent more than one client in a particular matter, sometimes those clients' interests can diverge. And so we have to be very careful when we have a group of petitioners whom we represent, because if their interests do start to diverge, we have to withdraw in representing some or all of them. And so even if it's the same project, people could have something in their petition. Some got an RFE, some didn't, some will get one, some won't, where their circumstances change such that it's no longer feasible or beneficial to have us or any one law firm. So it is possible, but it has to be done very carefully and with an understanding from the clients that there may come a point in time where we have to withdraw as their counsel. That's a very uncomfortable situation for the client, and it's uncomfortable for us. So if it can be avoided, we would recommend it.
Got it. That makes sense. Okay. All right. That's pretty much all the time we have today. So we'll wrap it up there. And for those of you who still have questions and are interested in pursuing a mandamus action, please reach out to Rohit and Steven. Their emails are on the screen there on the right side, and they'll be happy to take a look at your documents and set up an initial discussion with you to cover what the options are and get the ball rolling for you to try and expedite the process. And for anyone who has an interest in a current EB5 investment, please reach out to us at info@eb5an.com. And if you are interested also, as I mentioned earlier, in getting a copy of today's slides, please reach out to us, info@eb5an.com. And a video recording of this webinar will be sent to everyone who registered, so you'll get that automatically. And if you're looking to share that or just get a different link, it'll also be added on our YouTube channel as well early next week. So with that, I want to first thank Rohit and Steven for taking time out of their day to share their experience on the front lines with us. And yeah, I'll give them a minute to share any concluding thoughts that they have.
Steven?
Yeah, just very briefly, I'd like to thank everybody for their interest in the discussion and for some terrific questions. We are, available to discuss issues on behalf of investors, regional centers, NCEs. Obviously, this is something we do a lot of and are quite interested in. So if there are any questions, please do not hesitate to reach out to us, and we're happy to speak with you.
And this is Rohit. Thanks again for spending the time with us. Obviously, as I mentioned earlier, if you are contemplating it, proceeding with the mandamus, please do first check with your immigration counsel. From our perspective, if we're going to be assisting, we would obviously want their blessing. We're just looking to come in for a very directed effort, which is just purely on the litigation front. So we wouldn't necessarily be representing you in front of USCIS. But every case is specific, every case is unique, and so this is not necessarily the right fit for everybody.
Great, thank you both. And again, email us on the emails listed on the screen for any follow-up, and thank you for joining us today.
Thank you.